Potpourri Studies presents Case Digest. Civil Cases. Second case. Republic of the Philippines, Petitioner vs. LUDYSON C. CATUBAG, Respondent. GR. Number 210580, 2nd Division, April 18, 2018, REYES, Jr. J. Republic of the Philippines, Petitioner vs. LUDYSON C. CATUBAG, Respondent. Facts. Prior to their marriage in 2003, LUDYSON CATUBAG and Genevieve had been cohabiting with each other as husband and wife. Their union begot 2 children. To meet the needs of the family, LUDYSON took work overseas while Genevieve stayed in the Philippines to tend to the children. On 2003, LUDYSON and Genevieve got married. LUDYSON returned overseas to continue his work. On 2006, while working abroad, LUDYSON was informed by his relatives that Genevieve left their house and never returned. The relatives took care of the children. LUDYSON came back to the country to look for his wife. He proceeded to inquire about Genevieve's whereabouts from their close friends and relatives, but they too could offer no help. He traveled as far as Bicol, where Genevieve was born and raised, but he still could not locate her. LUDYSON subsequently sought the help of Bombo Radio Philippines, one of the more well-known radio networks in the Philippines, to broadcast the fact of his wife's disappearance. After almost 7 years of waiting and with the desire to marry again, LUDYSON filed a petition to have his wife declared presumptively dead. Issue: whether LUDYSON complied with the requisites under Article 41 of the Family Code. No. Ruling. Prevailing jurisprudence has time and again pointed out 4 requisites under Article 41 of the Family Code that must be complied with for the declaration of presumptive death to prosper. 1. The absent spouse has been missing for 4 consecutive years, or 2 consecutive years if the disappearance occurred where there is danger of death under the circumstances laid down in Article 391 of the Civil Code. 2. The present spouse wishes to remarry. 3. The present spouse has a well-founded belief that the absentee is dead. 4. The present spouse files for a summary proceeding for the declaration of presumptive death of the absentee. Notably, the records reveal that LUDYSON has complied with the 1st, 2nd, and 4th requisites. Thus, what remains to be resolved is whether or not private respondent successfully discharged the burden of establishing a well-founded belief that his wife, Genevieve, is dead. In Republic vs. Orslano Villanueva, the court expounded on the required diligence. The well-founded belief in the absentee's death requires the present spouse to prove that his/her belief was the result of diligent and reasonable efforts to locate the absent spouse, and that based on these efforts and inquiries, he or she believes that under the circumstances, the absent spouse is already dead. It necessitates exertion of active effort, not a mere passive one. Mere absence of the spouse, even beyond the period required by law, lack of any news that the absentee spouse is still alive, mere failure to communicate, or general presumption of absence under the Civil Code would not suffice. The premise is that Article 41 of the Family Code places upon the present spouse the burden of complying with the stringent requirement of well-founded belief, which can only be discharged upon a showing of proper and honest-to-goodness inquiries and efforts to ascertain not only the absent spouse's whereabouts but, more importantly, whether the absent spouse is still alive or is already dead. In the case at bar, LUDYSON first took a leave of absence from his work in the United Arab Emirates and returned to the Philippines to search for Genevieve. He then proceeded to inquire about his wife's whereabouts from their friends and relatives in Cagayan and Bicol. Next, he aired over Bombo Radio Philippines, a known radio station, regarding the fact of disappearance of his wife. Finally, he claims to have visited various hospitals and funeral parlors in Tuguegarao City and nearby municipalities. The court finds that LUDYSON's efforts fall short of the degree of diligence required by jurisprudence for the following reasons. First, he failed to present any of these alleged friends or relatives to corroborate these inquiries. Moreover, no explanation for such omission was given. As held in jurisprudence, failure to present any of the persons from whom inquiries were allegedly made tends to belie a claim of a diligent search. Second, he did not seek the help of other concerned government agencies, namely, the local police authorities and the National Bureau of Investigation, NBI. In Cantor, the court reasoned that while a finding of well-founded belief varies with the nature of the situation, it would still be prudent for the present spouse to seek the aid of the authorities in searching for the missing spouse. Absent such efforts to employ the help of local authorities, the present spouse cannot be said to have actively and diligently searched for the absentee spouse. Finally, aside from the certification of Bombo Radio's manager, LUDYSON bases his well-founded belief on bare assertions that he exercised earnest efforts in looking for his wife. Again, the present spouse's bare assertions, uncorroborated by any kind of evidence, falls short of the diligence required to engender a well-founded belief that the absentee spouse is dead.